for those not familiar with ALCs, they are courts that are not in the Article 3 independent judicial branch. They're housed inside agencies, and we found out that more than 40 agencies have these ALCs. So we're going to talk about a couple of court cases that are in progress right now that might give some substantive reforms on ALCs. But the reason we're here on Capitol Hill today is because what the courts are doing is not enough. Congress also needs to act. So we're going to make that case as well. The run of show today will be, the first speaker will be our special guest, Congresswoman Hageman, who I'm delighted is here with us. If we have time, she will allow some Q&A after her remarks, and then we will move on with the rest of the panel. And at the very end, we should have some time for Q&A for the rest of the panel as well. About Representative Hageman, she is one of the few, if not the only member of Congress who has actually litigated in front of an ALC. So she brings special experience to the table here. She represents the state of Wyoming and serves on the House Judiciary Committee, as well as the House Natural Resources Committee. She has distinguished herself in Congress as a leader on regulatory reform issues since coming to Congress, and we at CEI have had the pleasure of working with her on a number of legislative priorities this Congress. Before being elected to office, she was a litigator for 34 years who challenged federal overreach, protected property rights, and fought against unconstitutional and unlawful acts of federal bureaucrats. And she is also a former New Civil Liberties Alliance colleague of our panelist, Peggy Little. So, Congresswoman, thank you for being here. The floor is yours.
It is wonderful to be here. What an honor. And to be here with two of my former colleagues, Peggy Little and Kara Rollins here, who I've had the opportunity to work with both of them when I was with NCLA. You know, as a trial attorney, primarily focused on fighting back against federal regulatory overreach, I had an opportunity to try a lot of different cases in a lot of different areas, primarily focused in water and natural resources, but also on the constitutional side of things. But when I came to NCLA, my entire life kind of changed in truly getting a much better understanding of how pervasive and how truly insidious our regulatory and administrative regime has become. I had an office right next door to Peggy. We spoke probably almost every single day that I was back here in DC at NCLA about new things that were coming down from agencies. And one day I was visiting with Kara, and she made the comment that if you want to be a constitutional attorney, this is really the only area of the law where you will be dealing almost exclusively on constitutional issues. And one of the most important aspects of that is the court system itself. The Constitution, obviously, under Article 3, provides for district courts. That's how our legal system was set up, was under Article 3. But over time, these various agencies, through executive action, have created these administrative law courts and administrative law judges. And for those of you here in the room who are familiar with that, you also recognize that these agencies are much more successful when they appear in front of an ALJ than when they appear in front of an Article 3 judge. And as someone who tried numerous cases against agencies, I can assure you that even in Article 3 judges, you're always starting out where every single person in the room, including the person in the black robe, is on the other side. I learned very quickly when taking on the EPA or the USDA or the U.S. Forest Service or the U.S. Fish and Wildlife Service that any case that I had to overtry. So if I needed 15 witnesses to make a point, I would call 30. If I needed 27 exhibits to make my point, I would bring in 67, whatever the numbers were. I had such an incredible burden of proof to overcome the belief on behalf of even the Article 3 judge that whatever the agencies did was the correct thing. That one of the last cases that I tried was a lawsuit where a gentleman had moved an irrigation ditch on his property, affected 2.1 acres of land. The EPA and Corps of Engineers came in and concluded that that irrigation ditch was a navigable water of the United States, asserted jurisdiction over it, claimed he needed a 404 permit in order to clean out his irrigation ditch, and brought an enforcement action against him. When we went to trial, he was facing penalties of almost $65 million because at that time, the EPA could impose penalties of $37,500 a day. It's now over $59,000 a day, which is used by these agencies as a way to force you into a settlement, whether you have actually done anything wrong or not. But what happened in that case, and why I think it's important for understanding that even in Article 3 judges, you've got an uphill battle at times, the court concluded that it was my burden of proof to show that my client had not violated the Clean Water Act. It was not the EPA's burden of proof. It was my burden. So in these cases, the courts are even flipping the burden of proof of who's responsible for proving the case. When the judge made that determination, because obviously it was an enforcement action, we all assumed that the federal government would go first, present their case, and I would respond. When the judge ruled on a motion in limine that I had the burden of proof, I demanded that I then be able to go first, and I be able to present my case first. The EPA and Corps of Engineers were not expecting that kind of a move. Their first response was, oh my gosh, we need to set the stage. We're the ones that we need to be telling the jury what is what and how this all came about. And I'm like, no. If I have the burden of proof, I go first. And it allowed me to crush him in that case. And after a 2-week trial, the jury was out for 2.5 hours, and we ultimately won. But what I'm saying is that ALJ, being in a regular district court because of Chevron deference and the various deference doctrines, we already are starting, with not being on an even playing field. When you take it before administrative law courts, it becomes even a worse situation. And I know that Kara and Peggy both have had personal experience with this. You know the successes of NCLA, what they have been able to do in such a short period of time. I believe you have 3 cases up before the U.S. Supreme Court this term, maybe 4 cases so far this year. And they have tried these cases and why people should be litigants and the targets of federal regulatory action should be able to proceed in an Article 3 court versus an ALJ or an administrative law court. One of the things that we learned while I was still with NCLA is I believe it was the SEC where the ALJ side of the ledger was actually working with the litigation side of the SEC, which was quite a scandal for a very short period of time. But that demonstrates, I believe, that ALJs are not the independent arbiters that they claim to be. There are several things that I am trying to do as a member of Congress. And I would say my number one priority for my tenure in this role, no matter how long it is, has got to be regulatory reform and reform of the Administrative Procedure Act. The APA was adopted in 1946. It has never been amended. But again, as someone who has had to work in that realm in litigation for the last 25 or 30 years, I can assure you that the APA desperately needs to be amended. I am on in terms of my committees, as you noted, I am on the Judiciary Committee, but my subcommittees on Judiciary are Administrative Law and Antitrust. And another subcommittee is Constitution and Limited Government. And then I am also one of the only freshmen on the Select Committee on the Weaponization of the Federal Government. In terms of our Administrative Law subcommittee, that's overseen by Thomas Massey from Kentucky. He's the chairman of that particular subcommittee. And I went to him very early after I arrived here and said, one of the most important things we can do is revisit how rulemaking is done, not only how rulemaking is done, but how litigation is done in the administrative context. As we all know, and especially if you're someone who works for oil and gas companies, gravel companies, farmers, ranchers, some of the more disfavored industries right now, even though they're the ones that produce everything, it is very important that we have standing to challenge some of the things that are done in agencies. And that's an area where, especially in, say, the Endangered Species Act context or the NEPA, National Environmental Policy Act context, it can be so extremely difficult to get standing to challenge rules and regulations that may destroy your ranch or may destroy your ability to pursue oil and gas development or may shut down your gas station. even though you would think that you would have the ability to challenge the listing of a particular species if it's found on your property, should you pursue that challenge through an economic lens, the courts will oftentimes say you don't have standing to challenge this because that's not one of the issues we can take into consideration. So right now, and since I've been here, one of the things I've been working on is either standalone bills or a comprehensive package. We haven't decided yet what we're going to do, but we are planning on doing an administrative law reform. And I invite all of you, everybody in this room, if you have ideas of ways that you think that the process or that the APA should be amended, I invite every single one of you to get a hold of my office with your ideas. I've reached out to NCLA. I've reached out to a variety of organizations, CEI. I've reached out to folks and said, I have no pride of authorship here. I want to get this right. And one of the things that Peggy suggested that we do is that right now it is only the agency that gets to determine if they're going to use an ALJ. So if they want to drag Kara before, if they want to bring an enforcement action against her, they can choose to go into an Article 3 court or before an ALJ. Well, how about if we just level the playing field? It doesn't get rid of administrative law courts or administrative law judges, but it lets Kara make the decision as well. So in the Cochran case, for example, as that case proceeded, then she would have been able to say, I don't want to be in front of an ALJ. I'm going to make you go into an Article 3 court. And I think that move alone will substantially limit the kind of enforcement actions that these various agencies bring. Because right now they don't have any risks associated with bringing these cases. But if they're going to get bad case law, if they're going to get bad decisions out of an Article 3 court versus an ALJ, they may think twice before bringing that action. So that's just one of the areas in which I think that reform is drastically needed. One of the other things that I have done and that I have learned about since I have been here, and I actually had the good fortune of engaging in an oral argument today as a member of Congress, which we don't normally get to do, and maybe I shouldn't describe it that way. But the USDA is still attempting to force our livestock producers, our cattle producers, to use radio frequency identification ear tags. And I've been fighting them on this for 5 years. It's another form of surveillance. It has a price tag of probably anywhere from $500 million to $2 billion. We filed a lawsuit at NCLA, got it blocked, but they're back trying to do it now with a new rulemaking. But we asked for a hearing before OIRA and to explain why they should not allow this rule to go forward. And we had the arguments this morning at 10 o'clock, and we argued it from two standpoints. One was from the standpoint of that the rule is not necessary, that we have the highest quality meat and livestock in the entire world. We have very little by way of disease outbreaks in our country. But the other part was that they have failed to follow the policies. They have failed to follow the APA and the other executive orders related to rulemaking. And I thought that the argument went very well. I was extremely excited about it. It was fun to get back into that kind of a venue, although I was just sitting at my desk on the telephone. But I have missed engaging with something like that, where you actually get to present an argument and take questions and things. We'll see what OIRA does. But what we've pointed out is that with this rulemaking, they have failed to adequately assess the cost. They have failed to follow the federalism requirements and those sorts of things. So with that, I think it's probably best to just open it up to questions and focus on what your issues are. Again, as a member of Congress who has worked in this area for 25 or 30 years, I really do welcome your input as to ways in which Congress can fix the situation that we're in right now. Because I don't want to be doing it, toggling back and forth between administrations and executive orders and withdrawing executive orders and issuing new ones. We need stability and certainty in this area. Our litigants, our citizens deserve it. And I would like to actually accomplish something in this space that is good for the American public, because administrative agencies, regulatory agencies have become so pervasive in controlling every aspect of our lives that we have to make sure that we have an equal playing field, an even playing field, that people get the due process that they're entitled to, and that they have a chance of presenting their case, not just to an Article 3 court, but even if there are going to be administrative law courts, to ensure that that is going to be a fair proceeding when it does go forward. So again, with that, I'd be happy to take any questions that you all have. Yes, sir. I think you have a couple of issues there, potentially including a separation of powers issue. So I would have to think through that. But right now, there is the requirement that if you are going to change a policy, you have to have a rational and reasonable basis for doing so. And you're getting to the very issue of stability and certainty, which I think is so important for the regulated community. And I think that what I would perhaps try to do is further strengthen the requirements of what has changed to make the previous rule no longer effective. And an example I will use is, again, the RFID. In 2013, USDA adopted a rule for identification and traceability of livestock and said that livestock producers could use brands, back tags, tattoos, ear tags, and other forms of identification. And the purpose of this is if there is a disease outbreak, say brucellosis, then we can easily trace that particular cow or heifer or steer and make sure that we are addressing it and quarantining if we need to. Nothing has really changed since 2013. We haven't had any major disease outbreaks. There hasn't been an issue of traceability. There is nothing that would warrant imposing an entirely different $100 million rule, maybe $1 billion rule on that regulated community when nothing has changed to demonstrate that brands, back tags, ear tags, and tattoos don't work. And that's where I think that I would strengthen this, is forcing them to actually show what has changed. Another area that I think has been extremely troublesome since at least 2010 is the way that Title IX has been interpreted. And that's an area where you not only have the effort to make rule changes, but between dear colleague letters and guidance documents, which to me are the most insidious forms of administrative rulemaking that there can be, because there is no rulemaking, we have been able to create a situation where, in my mind, Title IX is no longer recognizable in terms of protecting women and girls in sports and in the education context. And much of that has been done without any rulemaking at all. But to the extent that there has been a rulemaking on it, that rulemaking, in my opinion, does not explain why they had to change and so dramatically change the definitions the way that they have. So I think where perhaps Congress, what we need to do in the legislation I'm talking about is really strengthening the demand that they explain why there is a need for a new regulation that is going to have dramatic costs on any particular industry. And I think if they have to meet that, perhaps they won't so readily move forward with rulemakings. But I like your ideas. Anyone else?
I have one if no one else. Oh, please, you first, sir.
Congresswoman, obviously, issue here, an expert. Do you think how much of it is public awareness with other members of Congress and staff, like they know the issue, like to the same level we do, or is it public awareness, or are people ready to ask for this? They're like,
there are some staffers here in the room who know quite a bit about it. And I have been working with them on the Judiciary Committee. And in fact, we're going to at some point be having a hearing specifically addressed to APA reform. That hasn't been scheduled yet, but we're working on it. And I don't even really have a framework for it yet, but that's something that we need to move forward with so that we can work up this bill and hopefully get it passed. It is as much a lack of public awareness as almost anything else. Unless you are one of those heavily regulated people, a lot of people don't understand the real impact of what's happened in this country, especially over the last 30 to 40 years. We all know it started with the New Deal, but I would say starting with Bill Clinton, it was at that point that because of what happened in 94 with Republicans taking the House, his agenda was shut down. And so from that point on, it was absolute rulemaking on steroids. And one of the rules that I filed a suit over was his roadless rule in 2001. And it was one of the very last rules issued under his administration. But the Forest Service issued a rule to deny access, management, and use to 58.5 million acres of land. Why that was so significant is it was the largest rulemaking in U.S. history. And I think it was a watershed moment because it demonstrated to the agencies there was very few bookends or restrictions on what they could do by way of rulemaking. And I think since then, things have just exploded. For me, I cannot possibly fathom under our form of government how an administrative agency could make a decision of that magnitude and not have it go through Congress. That to me is very clearly a congressional act, just like creation of wilderness areas is a congressional act. Yet once they got the roadless rule through, and I did get a nationwide injunction against that. I sued on behalf of the state of Wyoming and got a nationwide injunction against it. But because we had a governor that didn't defend it on appeal, it went into effect. And again, I think that that's when agencies said, well, Katie, bar the door. We can do anything that we want to. And so what the cost of regulations in this country is $14,000 per household. It's a hidden tax of $2.1 trillion, but most people don't even necessarily know it exists or know how it works. I'm doing as much as I can to educate my fellow members of Congress, but not a lot of people in Congress have the background that I do. And I think if you don't have this background and having fought these agencies the way that I have, I think it's difficult to know how all of these things are interconnected. But we're working really hard to educate people. We're working really hard to get this at the forefront of everyone's minds. And I think we're making some real progress. And hopefully this hearing will help with that as well.
You actually partially answered my original question of how do we get more members on board? It's talking to people, it's education. I guess I would say, what are your top 1 or 2 APA reform priorities?
I think standing has to be one of them, and especially for some of the statutes such as the Endangered Species Act. And so that may be more of a standalone issue that we need to address. It wouldn't be necessarily within the APA. But what I have found is, again, this lack of one side always gets standing and one side doesn't. And I think that has created an uneven playing field that we have got to address. We absolutely have to address that. Some of the other things are just like what we talked about, that these agencies, what I have found is that agencies get power by growing, and they grow to get power. The more they can regulate, the more that they can issue rules and regulations and guidance and dear colleagues letters and all of those things, that amasses power within that agency. We have to find a way to disincentivize agencies from continuously ratcheting things up and up and up and up. The American public, when you look at our Constitution and when you look at our foundation of who and what we are as a country, I'm looking at it right there. We the people. This is a government of, by, and for the people, not a government for the government, by the government, et cetera. We're the drivers here. And yet what has happened in our country and what has flipped, in my opinion, is it is now almost that we have become vassals of the state and servants to what the administrative state wants to do. So we have to, as we do the Administrative Procedures Act reform, as we work through that, we have to come back to a couple of what I think are really solid foundations: separation of powers. The legislative branch is who should be legislating because we're the ones that are accountable. I have to go back to Wyoming and answer for my votes, but nobody in the USDA does. I have to be accountable to all of the citizens of Wyoming and the people of this country. So we've got to get back to the separation of powers. And then we've got to ensure that we've got to find a way to disincentivize continuously ratcheting up more and more regulations on the citizens of this country. So those are kind of broad brush views of this, but that's what we're really focusing on and asking for advice of people. If you agree with that and you've got ideas of how we can do that, please get a hold of my office.
Congresswoman, that was fantastic. Thank you very much.
Thank you.
Thank you. I will. All right. Thank you very much. Those were very insightful and very useful remarks. We also have with us today a very distinguished panel, as well as me. So I mentioned earlier, I'm Ryan Young, Senior Economist with the Competitive Enterprise Institute. Also with me on today's panel is my colleague, Stone Washington, a research fellow at CEI and co-author with me of a recent paper on ALC reforms titled Conflict of Justice, Making the Case for Administrative Law Court Reform. We also have with us today Peggy Little of the New Civil Liberties Alliance. She is senior counsel there and is very active in some ALC cases at the moment, which we will hear about shortly. We also have Josh Robbins, an attorney in the Pacific Legal Foundation Separation of Powers Group, and his colleague at PLF and former CEI colleague, Will Yateman, who is a senior legal fellow in PLF's Constitutional Scholarship Team. We have a tight hour, so we will all be brief. I will start by going first, and then we will just go in order down the panel. So my goal here is just set the table for my other panelists, just kind of give a broad brush picture of what ALCs are and really what's wrong with them. So I want you to imagine that you have violated an agency regulation and you are being taken to court. But this is not a regular court. This is a special in-house court that is inside the agency that is accusing you. It is not part of the independent judicial branch as outlined in Article 3 of the US Constitution. In this special court, the agency chooses the judge. The agency pays their salary. You often do not have the right to a jury trial. The agency sets the procedural rules that you have to follow. The agency sets the rules of evidence. In some cases, the agency can withhold evidence from your attorney and you will not be able to see it. Regular court cases usually wrap up in a couple of months. ALC proceedings can take years and can cost millions of dollars. And the appeals process can be lengthy and draining unless you have massive resources that very few people enjoy. That's why the government wins almost every time in administrative law courts. In the Securities and Exchange Commission's ALC, the government wins more than 90% of the time. Compare that to about 60% of the time in regular courts. The FTC recently snapped a 25-year win streak in its administrative law court. And after that case was decided, the FTC commissioners overruled their own judge and handed themselves the win anyway. This is a broken system and it needs reform. And that is exactly why we are here today. As I mentioned earlier, there are a couple of promising court cases that will be decided soon, but what the courts are doing is not enough. Congress also has to act. We need hearings where people can tell their stories. They can put their names and faces in front of members and in front of the public. Congress needs to pass legislation that we hope will, at least in some form, move ALCs out of the executive branch and out of their regulatory agencies and into the independent judiciary where they belong. We're not necessarily advocating abolishing ALCs outright, but they do need to be abolished from the agencies and moved into the independent judiciary. As Congresswoman Hageman noted, this country is founded on the separation of powers. We can't have regulatory agencies being both judge as well as legislator, as well as executor. That is not how this country works. The way ALCs are currently set up, it's unfair, it's un-American. We need an independent judicial branch as part of our tradition of separation of powers and limited government. And with that, I would like to pass things on to my colleague, Stone Washington, who will give more information about how many ALCs they are, how they work, and what Congress can do to reform them. Thank you.
Thank you so much, Ryan, for your wonderful remarks. And thank you so much, everyone, for coming here. So you all have a understanding of administrative law courts, at least some kind of general understanding. And my colleague Ryan kind of spoke about the fairness problem that ALCs present. I'm just going to kind of talk a little bit about the origin of how me and Ryan kind of came about to learn about these in-house court systems and also speak about our two legislative proposals that we hope members of Congress will take seriously after this event. And so just a little bit of a background. So I've been working at CEI for almost a year and a half now. And it was about a year ago, last spring, that I was doing some research. And my research mostly focuses on financial regulation. And so I do a lot of analysis on the Securities and Exchange Commission and the Commodity Futures and Trading Commission. And I was shocked one time to learn about that as the SEC and the CFTC both have their own in-house tribunal. And I learned about the ongoing cases that were coming before the federal circuit courts and even the Supreme Court involving people challenging these in-house court systems, calling them unconstitutional. And so I was exposed to cases involving people like Michelle Cochran and Raymond Lucia and organizations like Axon Enterprises and George Sharkisy, people who were giving a Herculean effort just to be able to defend their basic constitutional rights and privileges before one of these shadowy court systems. And I was shocked because I took an administrative law class. I had a legislation regulation course. I only very vaguely remember any brief mention of an administrative law court and administrative law judges. But once I learned about this, it was very shocking. And I knew the regulatory system was already powerful and expansive, but the fact that these already very powerful agencies have their own in-house court systems just really troubled me. And so that inspired me to conduct a lot of research to try to get an understanding of what administrative law courts are, why do they matter, what are some of the pros and cons of these. And that kind of expanded over a series of blog posts that I did through CEI. Then my colleague Ryan and I did an op-ed for the National Review. And just after that, we published our conflict of justice paper in December of last year. And just to kind of give you a scope, there's about 44 known ALCs that we have, and they exist across executive departments, sub-agencies, independent agencies. And it's just very shocking to see this, the fact that the executive branch is treated in this special way where they are the only branch of government that has their own kind of in-house judicial system where they can justify their own executive actions against we the people. And it seems like it creates a major separation of powers conflict. And so I'm going to propose just two legislative solutions that we feel can remedy the problem that ALCs present. And these solutions were inspired by another paper by our colleagues, Dan Greenberg, general counsel at CEI, and Devin Watkins, an attorney, who published a separation of powers paper at CEI.org. And towards the end of their paper, their legislative remedy for these in-house tribunals was in two parts. One is a gradualist approach, and this requires Congress to pass legislation that specifically moves administrative law courts into the Article 3 court system where we feel they belong. And this can happen agency by agency or a few agencies at a time. Happens gradually over time. So you ensure that one presidential administration doesn't stack the deck in their political party's favor. And so once they're moving to the Article 3 system, they would take on new trial courts. And this is understandable because the founding fathers didn't create a limit in terms of the size of our judiciary. They understood that over time, people's would face new problems and issues that would probably have to be accommodated by a larger court system. And so this would just be in line with that. And then we're also taking the bureaucratic expertise of administrative law judges, because we do see they have value. They understand a lot about a specific policy area, but we can use that to bolster the ranks of our existing trial judges in the our Article 3 system. The second legislative proposal is the magistrate model, where we would create a special wing for administrative law courts to be housed in the Article 3 judiciary. These would basically be serving as like a specialized court system, like we understand a bankruptcy court where they have exclusive jurisdiction over a certain area. And for administrative law judges, these would be over administrative matters. But they would be basically, magistrate judges would be akin to administrative law court judges. They would basically hear a case, and if a person didn't like the outcome, you can appeal that case directly to a district court or a circuit court. And so you basically kind of move ALCs in our administrative, our American legal system, and they're just kind of fitted in the flow of cases being appealed that way. And so that's basically our proposal. And I just want to end with a quote from the Federalist Paper number 78. And I think this really captures the problem of administrative law courts in terms of the founding fathers didn't envision a political branch of government to have their own court system. Alexander Hamilton, writing Federalist number 78, envisioned an independent judiciary, which is free from any higher power of an administrative bureaucrat dictating how a judge should render their decision or pressuring them to render a decision in a certain way. And this line captures it all. It says, there's no power above them. And these are judges. No power above them to control any of their decisions. There's no authority that can remove them, and they cannot be controlled by the laws of the legislature. In short, they are independent of the people, of the legislature, and every power under heaven. The independence of the judges may be an essential safeguard against the effects of occasional ill senses of humor in society. These sometimes extend no farther than the injury of private rights of a particular class of citizens by unjust and partial laws. So with that, you can understand administrative law courts, they're not independent. They don't fit the dynamic that Alexander Hamilton and the framers envisioned. And I feel that they very much need to be under the one branch of government that isn't politically controlled, that is the judiciary. And so with that, I will pass it on to my next panelist. And thank you all for your time today.
Thank you very much, Ryan and Stone. They have written a great paper. I recommend it to all of you. It has a lot of detail in it that I will not be able to do justice to. And I will just touch on some of the points and some of the insights I can bring to those points, because NCLA represented both Michelle Cochran, who had really a game-changing decision at the U.S. Supreme Court, which allowed people challenging the constitutionality of administrative law adjudication to take that claim into a real federal court first before they have to undergo the unconstitutional adjudication. That was a watershed decision. We also represented Ray Lucia, who brought one of the first challenges to the fact that the ALJs were not even constitutionally appointed. It's pretty shocking that these systems, which have been in place since 1947, have been operating outside the Constitution and contrary to the separation of powers. One of the points that Stone and Ryan make in their papers, that only the ultra wealthy can navigate through two systems of justice. These proceedings go on forever. It is shocking. And when I argued Michelle Cochran's case before the Fifth Circuit Court of Appeals en banc, 16 judges, I think the point that really seemed to land home with them was she had been in that system, just administrative part, for 4 years. She'd been tried by the SEC for 10 years before she got the decision out of the Supreme Court. Ray Lucia was tied up in proceedings for 6 years, 8 years before he could settle. And I'll get to settlement in a moment. George Jarkissi, 7 years before he could get a decision out of the commission in his case. A gentleman named David Bandemir, 10 years. This is just unheard of. This is straight out of Kafka. You were talking about people who are appealing their cases to the very people prosecuting them and tied up in those proceedings for 10 years in a system that is rigged against them from the beginning. So I think the suggestion made by CEI that we need to enlarge the judicial branch to take on these administrative law judges is the correct one. I would not put the same ALJs in, and here's why. First of all, the idea that they have expertise is a fiction. When we filed our amicus brief in the Lucia case, I investigated the backgrounds of all 5 SEC judges. 4 of them had their only prior experience was as Social Security judges, and the 5th one had been at the FCC, Federal Communications Commission. Not one of them had a shred of background in securities laws. This is a total fiction, and yes, they might acquire expertise over time, but all of that expertise is acquired as an employee of the agency with the agency's own bias and viewpoint inescapably infecting their point of view on this. So I think we just need to abolish the ALJs and appoint Article 3 district judges as we do generally. I think that's the correct solution constitutionally and also practically. There is no congressional oversight or control over this process. regular district court judges have to report to the administrative conference on the judiciary as to the time from the beginning of their case to resolution. And if they average more than maybe 2 years, 2.5 years, they're in trouble. You would not be racking up a time to decision of 4, 8, 9, 10 years in a federal court. It simply would not be permitted. I want to also report on something that doesn't get discussed at all. Harriet mentioned it briefly, and this was what's called the control deficiency. And that is where the SEC had to make a filing in both the Cochran case and the Jarkissi case that its enforcement staff had accessed the files of the administrative law judges during the proceedings. Not only was this a scandal, it is an ongoing scandal. They will not give us anything in FOIA. We've taken them to court in the DC District Court and in the Northern District of Texas, and we still have no real disclosure about that. What that tells us is that men are not angels. They will cheat. They will look at the judge's file if they can get to it. That is not permitted in a real federal court, and we need to put the judicial power back in the branch where it was originally designed to be. I think also one of the questions from the gentleman down there was about public awareness, and this has come up in the panel as well. Because it is, why are we just sort of understanding and recognizing the size of this problem now, since these courts have been around since 1947? Harriet is right that around 2010, a whole lot of things changed in her field of the EPA, but also Dodd-Frank expanded the jurisdiction of what the SEC could take into administrative law proceedings. And they have enormous power to ruin people's lives, to take away their profession, their livelihood, their reputation. It's a shocking amount of power, and it needs to be returned to the judiciary. But one of the reasons we do not know about the SEC, which is one of the most active agencies and one of the most powerful, is a pernicious thing called the gag. Because the cost of defense runs into the millions of dollars, 98% of the people who get charged by the SEC settle. And they are required to sign a gag that says they will never discuss or criticize the government's case against them for the rest of their lives. This is wildly unconstitutional. NCLA has been fighting it for a very long time, but it does go a long way to explaining why there is not public awareness of these cases. And I cannot encourage Representative Hageman and anyone else here in Congress that having public hearings where people can talk about their cases and be lifted from the horrible imposition of a gag on them about what goes on in these proceedings is essential to raising public awareness about these proceedings. So I'm just delighted that CEI has taken the lead on this, and I hope to see more of you in hearings to come. Thank you.
Thanks to CEI for putting this together. I'd like to address one of the biggest impediments out there to successfully litigating agency adjudication challenges, because as it turns out, it's something that Congress can address now. That impediment is a 1977 Supreme Court case called Atlas Roofing versus Occupational Health and Safety Review Commission. And in that case, the court gutted your right to a civil jury trial. After Atlas Roofing, the Seventh Amendment right to a civil jury trial no longer applies when Congress creates new legal requirements that administrative agencies are authorized to enforce. This opened the door to an explosion of administrative tribunals, which Peggy was just describing, that, among other things, impose fines. And the imposition of fines is something that would normally require a jury trial. This approach is completely wrong and ahistorical, and I want to give you two illustrations as to why. First, juries are a critical check on the enforcement of the law, especially when you are being pursued by the government. The American colonists pre-revolution understood this well. In the 1730s, the colonial governor of New York, William Cosby, tried to recover some of his predecessor's salary by having the Supreme Court of New York sit as a juryless court of equity. That case should have been heard by a jury,
but it appears likely that Cosby thought he would lose in front of colonial jurors. This maneuver generated significant backlash from the colonists, and the printer of much of this criticism was a man called John Peter Zenger, who was prosecuted for seditious libel. Fortunately, Zenger was acquitted by a jury. Second, the ratification debates of the Constitution already settled the question of congressional control of civil jury trials, and Atlas Roofing's position lost. The lack of a civil jury guarantee in the original Constitution was an animating issue for the Anti-Federalists in their opposition to the ratification of the Constitution, and from the Zenger episode, you can see why. The Federalist supporters of the Constitution took the position that the absence of a civil jury guarantee was fine, because Congress could simply provide for civil jury trials where appropriate. This obviously was not persuasive, and we ended up with the Seventh Amendment. But Atlas Roofing makes it as if this debate never happened. At the Pacific Legal Foundation, we will continue to litigate cases to restore the Seventh Amendment as a limitation on Congress. And in fact, we just filed a case on Friday to do just that. But in the meantime, Congress can actually fix this problem itself by providing for jury trials and administrative adjudications through proposals like the one Brian and Stone have put forward today. Thank you.
I'm actually going to remain seated in the interest of saving time to leave time for questions. So very briefly, I want to make two quick points, two points in 2 minutes. The first relates to the history of regulatory enforcement, and the second relates to the scope of the constitutional problem. So regarding the history, very briefly, in 1970, at the start of the 70s, there were zero statutory authorizations. I'm very sorry. I'm a loud guy, so I was hearing myself. At the start of the 70s, there were zero statutory authorizations for agencies to pursue money penalties, domestic regulatory agencies to pursue money penalties in their administrative law courts. Today, there are 193 such provisions, all right? The vast preponderance of which were enacted in the late 70s and throughout the 80s, all right? In 2022, agencies imposed at least $10.2 billion of civil penalty, or civil money fines, civil penalties in their in-house adjudication. That was across about 1,400 cases. What's my point here? It's that this stuff is new. Peggy had mentioned earlier, why aren't people talking about this? These money penalties, 7 of which exceed $2 million per violation. I mean, these are big deals. Most of them, the hundreds of thousands of dollars per violation. They were not around at the founding of the administrative state. They were not around when the grand compromise of the Administrative Procedure Act, the Constitution of the administrative state, was reached in 1946. So my point here is that they're new, they're novel. As Peggy noted, the Dodd-Frank was crammed full of new adjudicative authorities for the SEC and the banking regulators. We're seeing those the chickens come home to roost, if you will, now. Congress pushed and pushed and pushed, and finally it pushed too far. My other point, very briefly, defining the scope of the problem. No one here, no one who cares about the administrative state thinks that we've got some big Article 3 constitutional problem with benefits, with Social Security. Very few are going to really disagree that agencies can use their in-house courts to take away or suspend licenses that were granted by the government. The government maintains a proprietary interest in these licenses, having created them. Now, what gets our constitutional goat is these money penalties. That's what incurs the Seventh Amendment concerns. That's what incurs the Sixth Amendment concerns. That's what incurs these Article 3 concerns. My broad point here is that the ones we care about are a small slice of administrative law courts. So just to give you, I've got a number here to give you some perspective. So I said, pursuant to about 200 odd statutory provisions, agencies in 2022 imposed $10 billion worth of fines across about 1,400 actions, okay? Well, there were 350,000 Social Security cases that year. there were about 50,000 cases in the Office of Medicare Hearings Appeals. My point here is that the ones we care about are literally less than 1% of the administrative state. This is a problem that is fixable. This is a recent problem, and it's a relatively narrow problem. That's not to in any way understate how big the problem is. I mean, it's $10 billion big. But it's perhaps, I'll put it this way, when you engage with progressives or people who support administrative policymaking, they'll be like, oh my Lord, if bureaucracy comes out the wrong way, it'll sink the entire administrative state. We'll have judges running Social Security. Oh, it'll be awful. It's just not true. I mean, what we're talking about, again, is a slice of the administrative state, the most odious, objectionable slice of the administrative state. So that's my 2 cents.
Thank you, Will, and thank you to all of our panelists. It looks like we have a few minutes left over for Q&A, so if anyone has any questions, please raise your hand. Yeah.
In what way can Congress use its power of the purse to stop some of these bad agency actions? Like you were talking about the SEC gag order. Can Congress just say no money by the SEC should be spent on gag orders and things like that?
Well, that would certainly be refreshing. I think they need to get rid of the rule, and we're working hard at that. We're hopeful. We got a decision, unsurprisingly, from the SEC denying taking the gag out, and so we're going to be taking that to a Circuit Court of Appeals in just weeks, and we are hopeful for a good outcome. We got a great dissent from Commissioner Hester Peirce, which really lays out just a host of constitutional and other problems with that rule. But yes, Congress should use the power of its purse. I think it can defund the ALJs, and while it's doing that, fund new district court judgeships. Right there, you've solved the problem. And you're only talking about, as Will says, you're only talking about, in the case of the SEC, I think they're down to 2 or 3 judges now. They were at 5 when I first started this work. The FTC only has the 1 judge. And if you exclude the Social Security and veterans and benefits judges, it's just not that big a change. And all it does, by using the power of the purse and its power of legislation, is you move those positions into new district court judges of people who go through the confirmation process, who are seen to be fair and unbiased, which is so important. And this is why I really do oppose moving ALJs who are already very used to ruling in favor of the agency. I think that those positions just need to be made obsolete, and then create new district court judgeships. If the people holding an ALJ want to apply for it, they sure can. But I think it needs to be a different process, and one that ensures a lack of bias and fairness, and the fact that a person hailed into court before that judge is guaranteed a fair and impartial hearing.
Yeah, Sean.
Just to understand, how much actual control the agencies have over the ALJs? Is it a direct control situation, or is it something closer to a sort of cultural thing? The ALJ, people in the ALJs, or people who were picked or appointed and are sympathetic, just simply sympathetic of the agency that they're
I can speak to that. It seems like it varies across certain agencies, depending on if it's like an executive branch or an independent agency. But I know a lot of times I've seen that administrative law judges are typically they're employees of the actual agency, so they really have to kind of follow a specific process and agenda that the agency itself kind of lays forth. And I think when you look at certain agencies that have a great deal of control over their judges, I think the NLRB is an example. They basically the board itself controls every action of the ALJ, and a big controversy that I've seen is that I think the NLRA, the act itself, actually allows the legal assistant of the board to look at a draft opinion written by an administrative law judge, and they can revise it, modify it, or change whatever they want before it actually becomes finalized. And it just seems like they can exert so much power over the process of the judge's decision. But yeah, it does seem like that the agencies, for the most part, do exert a lot of control.
We have time for one more question if anyone has one. And if not, I do. Seeing no hands. I have a question for our PLF crowd here. You guys have a fantastic project focused just on administrative law court reform. Could you, Josh, or you, Will, please just explain what you're up to with that briefly?
Yeah, so at PLF, one initiative that we've launched is to end agency adjudication. So the PLF is bringing to bear all of its resources, the litigators, our scholarship and policy team, the communications team, to really bring a focus to this problem of agency adjudication that we've been discussing today, and to increase the number of cases that we're litigating to try to bring this to an end. So there are appointments clause problems. Stone was just describing with some of these officials. The one that's a particular problem for Will and I is the judicial officer at the Department of Agriculture, who gets to make final decisions in these adjudications and is just handpicked by the secretary, doesn't hold an office or anything. In any event, so these appointments clause issues, the Seventh Amendment, due process. We've really trying to zero in on this and bring cases that we can hopefully litigate as far as we can and overturn some of these troublesome precedents like Atlas Roofing.
Well, thank you both. Thank you to all of our panelists, and especially thank you to all of you in the audience who came here today. Hopefully we learned a little bit about what ALCs are, how we can raise awareness about them, what's happening in the courts, some potential good news coming in the next few months, I hope. And also what you in Congress can do about ALC reform, from holding hearings to passing legislation to discussing the many different ways we can reform ALC. So I want to thank you for your time and your attention today. And if any of you have any questions at all about ALCs or what you or your boss can do about them, please reach out to us. Come talk to us after the panel, send us an email, find a way to message us. We'll be happy to work with you in any way we can. Thank you.